Well, hello everyone. I'm Lynn Halltain. I'm the Executive Director of the Victoria Law Foundation, and it's my great pleasure to welcome you to the opening session of our International Access to Justice online forum, held in partnership with the University of California Irvine Law Civil Justice Research Institute. It's important to start, as we mean to continue, with a commitment to respecting diverse views, a recognition of the very many factors which bring us to where we are now, and that there is always opportunity to improve access to justice. So in that vein, it's my privilege to acknowledge the law and the law of First Nations peoples everywhere, particularly here in Australia, as well as California, British Columbia, and Aotearoa, New Zealand, from where our panelists join us today. I'm on Boonwurrung country today, part of the Kulin Nation in southeastern Australia. And on behalf of all of us, I pay my respects to the elders and to all the generations of First Nations peoples, acknowledging in the case of this part of the world, these lands were never ceded. We recognise the impact of colonisation, its legacy of injustice, and the marginalisation of Aboriginal and Torres Strait Islander people. And we believe that acknowledging the past is an essential step in building a better and more equitable future. Well, the next 3 days are a smorgasbord of ideas and conversations with an extraordinarily impressive lineup of participants on really pressing issues in access to justice. And I hope very much that you can participate in lots of them. So today, for example, we're talking legal tech in just a moment and how it can support better access to justice. Then the next session is deregulation of the profession. And then we'll round off proceedings for today, at least, with a dive into administrative data. How do we make the data itself smarter and the use of it more effective for people and systems? But fear not, if you miss something, recordings of all the sessions will be available after the fact. So if you miss the start or the finish of a session, you can always revisit it in the recording. A few housekeeping notes before we get our show on the road. Every session has its own link, which you will have received with your registration. But if you want to see another session, all the links are in the program and on the VLF website. So just go there and click on the link. And if you're rolling on to the next session today on deregulation of the profession, we'll post the link to that session in the chat towards the end of this one so that you can make a very smooth transition. And being a webinar, only the panelists today can be seen and heard. All other mics and cameras are muted. And please use the Q&A function just to ask your questions and to upvote other questions. I will very much look forward to your contributions, and we'll get to as many of them at the end of our presentations as we can. But like good meetings, a good conference is one that holds relatively to time. So I'm going to crack on and introduce you to our very first panel on legal tech and access to justice. We'll hear short presentations from each of our three speakers, and then we'll open it up for Q&A. I'm not going to give the full background to all our speakers today. You can read of their enormous achievements in the program, but we are truly delighted to have with us Richard Rogers, Acting Chair of the Civil Resolution Tribunal in British Columbia, Canada, Bridget Toy-Cronin, who is Director of the Civil Justice Centre and Co-Director of the Otago Centre for Law and Society, and Senior Lecturer in Law at the University of Otago, Aotearoa, New Zealand, and Margaret Hagan, Executive Director of the Legal Design Lab at Stanford University in California. So very, very warm welcome to all three of you, and I will now hand the baton to Richard for the first presentation.
Thank you very much, Lynn, and I want to thank the forum organizers for inviting me here today, or tomorrow, or yesterday, as the case may be for some of you. Just give me a moment while I share my presentation and hope that it works.
It's all good, Richard.
Thank you. Sorry, it's just the one other screen keeps covering everything else up. Apologize for that. So the Civil Resolution Tribunal, or CRT, is committed to reconciliation with Canada's Indigenous persons. And so I want to start by acknowledging that I am speaking with you today from the traditional territories of the Lekwungen speaking people of the Songhees and Esquimalt nations here in British Columbia. So as Lynn mentioned, I'm the current acting chair of the Civil Resolution Tribunal, and I'll be speaking to you just about our user-focused dispute resolution services and a little bit about the history of the CRT and how it operates. So the CRT is part of British Columbia's justice system in that our dispute areas or areas of jurisdiction were diverted to us from the court system in order to reduce the court's workload and increase access to justice for the citizens in those areas. The courts still have oversight over the Civil Resolution Tribunal through a judicial review process, but that does come with a high level of deference in most of our dispute areas. As far as we understand it, we were the first online tribunal in Canada and one of the first in the world. Of course, now after 6 years of operations, things have changed around the world, and of course, COVID has had a lot to do with that as well. One of the tenets of the CRT is that we take the justice system to the public rather than requiring that they come to us. And that applies both in the physical sense that people don't have to travel down to a courthouse, file documents, return for a trial, and so forth, but also in terms of ease of access and that we make the process simpler and easier for unrepresented parties to understand. This slide shows the history of the CRT's jurisdiction since we began operations in 2016. The bulk of our disputes currently stem from our initial areas of jurisdiction, which is in strata or condominium disputes, or also in small claims up to $5,000 Canadian. Additional areas of jurisdiction have been added over time, and most recently back in May of last year, we were given jurisdiction over disputes related to the government's motor vehicle insurance scheme related to personal injuries there. We have a specific legislated mandate that requires that we provide accessible, speedy, economical, informal, and flexible dispute resolution services. And there are also several other provisions in our legislation that reinforce this philosophy of both online access to justice and that the CRT is somewhat different than a court. And that's reflected in the CRT's key attributes. We use human-centered design and in order to build the system around the public and their needs. And we leverage innovation to achieve these 5 goals, which is timeliness, and most of our disputes are resolved in 60 to 90 days. We provide flexible processes, which includes mediation type services for the parties. Accessibility, prioritizing the needs of those who may have barriers accessing justice. Affordability, and in that we have restriction on the participation of lawyers, but certainly try to level the playing field even where lawyers are involved. And efficiency, we are required to be responsible for our use of public funds and act proportionately or provide proportionate dispute resolution processes. This slide also reflects those principles and the fact that we have focused on inclusivity as being a core CRT value. There's a number of items listed here, but some of the highlights are that we try to strive for all of our decisions, our information, and other material being at a grade 6 reading level. We provide simultaneous telephone interpretation in over 200 languages to our users. We also take steps to ensure our staff and our tribunal members have competency training in various cultures, and that all of our members have trauma-informed practice training. We have made a lot of efforts over the past several years to ensure that parties are able to indicate to us their pronouns, and we ensure we use them during the dispute resolution process, as well as the other parties. We also provide support to our Indigenous participants if they want it through assistance from an Indigenous navigator who provides them with customized services. This slide depicts our user-focused design process. And that starts with identifying a requirement, whether that's a result of new online functionality we want to create or legislative changes or something similar to that. The first step is to develop the initial design and prototype to meet those requirements. And then we test that initial prototype with a small group of prospective users, then refine it into a beta version and test that with a larger group of potential users. The next step is to refine that and then move it into production. And even once it's moved into production, we have a very vigorous process for monitoring feedback from parties, including a user survey that we ask them to complete at the end of the process. And so we'll monitor the results from that, which may result in identification of further tweaks or changes we need to make, which results in another requirements and starts the cycle all over again. This slide depicts the 5 steps in our dispute resolution process. The first is getting started, which is our Solution Explorer, and then the application process, which is online, as are most of our activities now, through a secure CRT account. Negotiation step, where it's just the parties themselves trying to resolve the dispute. And then we will have a staff case manager step in and provide facilitation services to try and help them reach an agreement. And if that fails, then we do have an adjudication process where independent tribunal members will consider the facts and arguments and render a final and binding decision. The first step, as I mentioned, is our Solution Explorer, which provides guided pathways for each of our areas of jurisdiction. That's a series of interactive questions that help the user narrow down the problem, and then we can provide information more specific to that area of dispute. Along the way, we provide plain language information about the dispute area and its relevant law, as well as potentially related issues such as limitation periods. Solution Explorer is free. It's available 24/7, 7 days a week, and we try to update the content fairly regularly, usually at least once a year or whenever there's a change in law. We have, I think it was over 95,000, maybe over 100,000 users of the Solution Explorer so far. And I note that of those users, only about 10% of them have continued on and started a formal dispute resolution process. So about 90% do not. We don't have good data on exactly why that is, whether some of them are multiple users of the same exploration, but definitely there's an indication that the Solution Explorer is of assistance to our users. So the first step, or the next step after the Solution Explorer, is to start the formal dispute resolution process if they haven't resolved it using the Solution Explorer tools. And the intake process includes an online application. Staff do review the application and confirm that CRT has jurisdiction, sometimes going back to the applicant and getting more information or clarification. The CRT assists with service of the dispute notice or notice of the dispute on respondents. Those respondents who file dispute notices, we review those and assist them as well. And if the response is not filed within the required timeline, then we have the ability to issue a default decision. And I've just got a series of screenshots here. I'll try and skim through quickly, but just this one highlights that we ask the parties to disclose potential barriers to their full participation in the process, and we do have strategies for addressing them to the extent reasonably possible. As I mentioned, there is a statutory restriction on the participation of lawyers. So in many cases, parties have to request CRT approval to have a representative. And this screen also shows that request, but also shows that we ask participants, including those representatives, to just declare their pronouns and advise us if there are any preferred names they want us to use. There was a change we made in 2019 where the CRT, in most cases, will serve notice of a dispute on the respondents. The applicant does have the ability to indicate they want to do it, and there are some cases where the CRT will not. However, we regard that as another example of making the process easier for unrepresented litigants to access and navigate. As well, we've also found that it has resulted in an increase in the proportion of disputes that result in a response being filed, and therefore we've had fewer default decisions since we implemented this process in 2019. The next stage in our dispute resolution is negotiation. As I mentioned, that's just between the parties, but we do provide an online secure platform for them to conduct those negotiations in. It's not mandatory that they do so, and we receive about 1% of our disputes that reach this stage are resolved through the online negotiation. It's about a 2-week period while they're in this negotiation platform, and essentially that's a waiting period while we assign the case to one of our case managers. It requires very minimal resources to support this. It's essentially just the parties, but they do have the option to let us know if they've resolved the dispute or if there are problems with the other party. This is just a screenshot from that messaging system. The next stage is our facilitation or reach an agreement stage, and that's where we do assign a case manager who has mediation training to try and facilitate dispute resolution. The facilitation process is quite flexible. It can be asynchronous or synchronous. We find a lot of our case managers are effective at using both telephone and emails to communicate with the parties. And in many cases, even if they can't resolve the entire dispute, they can resolve some of the claims or some of the issues in that dispute. And then finally, if parties can't resolve a dispute consensually, we do have this final step of getting a final binding decision from our decision makers. The adjudication process, like the rest of our steps, is entirely online. The parties use their CRT account to upload evidence and submit their arguments. There's also a process for developing an agreed statement of facts between the parties. Our tribunal members or adjudicators will then review the evidence, the arguments, and any of the other records related to the dispute through their own secure portal. And the decision maker can go back to the parties or have staff go back to the parties to request clarification or request additional evidence or submissions on a particular issue. And in rare cases, the tribunal member may direct that an oral hearing component be scheduled, and that would usually be done through Microsoft Teams in our instance. And this is just a screenshot from what the parties would see to upload evidence, and consistent with our continuous improvement approach to things. This is currently in the process of being updated, but I didn't have a screenshot of the new version. Similarly, this is the arguments area where they would input their arguments. And again, this is also in the process of being updated based on feedback we've received from both participants and from staff. This is a screenshot of what the members will see essentially at the high level of a dispute ready for decision, and they can click into the claims descriptions, the evidence, and the parties' arguments. Once the member is satisfied that they have what they need to make a decision, they will draft a written decision. They are required to make their decisions as brief as possible, ideally 10 pages or less, and plain language again. We publish all our final decisions on our website, and they're fully searchable by both lawyers and the parties themselves, and we've linked them back in some cases to our first step in the process, which is the Solution Explorer. And so I will stop there. I do have some slides on CRT statistics and performance, and certainly if it comes up in the questions later after the other panel members, then I'd be happy to answer those questions and refer to the slides if necessary. So for now, thank you very much for your time. I look forward to your questions later on, but I'll pass it off to the next panel member now, Bridget. Thank you very much.
Tēnā koutou katoa, e mihi ana ki te iwi o Ngāti Wairere, kei Kirikiriroa e noho ana e Nainei. My greetings to you from New Zealand, and I acknowledge the iwi of Ngāti Wairere on whose land I'm presenting from today. So I'll just share my screen with some more slides. Sorry, we've got slideshow, play from start. There we go. So obviously, legal tech and access to justice is a really big topic, and my research covers a big, broad ground within this area. My starting point is really unrepresented litigants and dispute resolution. So that's the perspective, and a lot of my research comes from that perspective. And obviously, Richard's just presented the CRT, which is a shining example of legal tech in access to justice, and is often held out as one of the examples of where it goes really very well. It's important to keep in mind that sometimes legal tech doesn't go so well, doesn't deliver access to justice. So for example, my colleagues and I did a review of a chatbot, which was to provide advice on employment disputes. And we tested it with lots of things. And one of the things we put in was a situation where someone had been getting racist jokes told to them at work. And this is the response that the chatbot gave. I bought my friend an elephant for his room. He said, thanks. I said, don't mention it. So the chatbot picked up the word joke and told a joke instead of replying to this. So there's both a great side to tech and some not so great sides to tech if it goes wrong. And I thought the way I'd approach this presentation with 10 minutes is just to get some key ideas across to you that I've learnt from my research. Especially, I know there's people coming from a lawyering perspective or government, lots of different perspectives. So hopefully there's something of interest here for you. So 4 myths to dispel first, and then 2 key lessons that I'd like to pass on. The first 2 myths come from a really kind of pro-tech perspective, I would say. Number 1, that the robot lawyer will be here any minute now, often illustrated by these kind of cyborg lawyer confusingly holding a gavel. The idea that suddenly there's this AI on the horizon that's going to come and save us all. Everything's going to be sorted. Access to justice will be resolved very shortly by AI. But the mythical robot lawyer does not exist aside from in these sorts of images. Legal tech and access to justice is really about using existing, often quite basic tech that's underutilized in the legal arena to scale up and solve justice problems for a lot of people. As the Hague Institute for the Innovation of Law has suggested, what we really need to focus on is scale rather than going for these very tech-heavy solutions. So that's number 1. There's no robot lawyer around the corner. Let's try and focus on accessible tech and scale that up. Number 2 is that with the right assistance, then from tech, once we've got good tech, then in-person advice and assistance is not going to be needed. And this idea is, again, somewhat like the robot lawyer, but maybe a little more realistic, that once we've got enough tech tools in place, then really that need for in-person advice will fall away. And this is really problematic because people still want that in-person advice. I'm with one of my colleagues doing a study at the moment, analysing advice bureau data. And just yesterday, we found a quote from someone who was talking about the fact that even though they'd found information online, they really wanted to speak to someone in person about their problem. And this is this idea that really tech has to be integrated with in-person advice. It's not one or the other, it's often both. And as Roger Smith, who writes a wonderful blog that if you're not aware of, then look up on technology, law and access to justice, he's suggested the acronym CLASS, or Combined Legal Assistance Support Services, where we're thinking about both tech and in-person advice and how we can integrate those and have them support each other. Now, the next 2 myths I want to talk about come from more of a tech skeptic perspective. The first one is that lawyers are the gold standard. And some of you who are old enough will recognise Lionel Hutz from The Simpsons here. Not all lawyers are created equal. And now some of you that might be very obvious, but I think it's worth pointing out. I've found in my research that sometimes when people are thinking about alternatives to lawyers, they have this idealized practitioner in their mind that they're comparing the alternative to. So they're thinking about a lawyer who has great interpersonal skills and is expert in their field and is affordable and accessible. And unfortunately, that's just not really a realistic picture of how all lawyering goes down. And this became very evident when I was doing research into litigants in person. It was also evident in research that I recently did with a colleague, looking at how lay people and lawyers plead claims. And we had lawyers and lay people plead a claim, and then we had judges evaluate these claims and tell us, they didn't know who was a lawyer, who was a lay person, and tell us what they thought of the claims. Lawyers generally did better, but some of the lay people did really well. And unfortunately, some of the lawyers were not so good, such as this comment from a judge: "I hope this isn't a lawyer," but it was a practitioner of more than 10 years experience. So we have to keep in mind when we're comparing legal tech alternatives to lawyers that not everyone gets the best lawyering that we maybe imagine in our heads. The other one that sometimes causes tech resistance is the idea of the digital divide. There are lots of vulnerable people, and particularly people who need access to justice, who simply don't have access to the tools or the legal capability to engage with legal tech. I would say that digital by default, the idea that you just go down the digital path, is extremely dangerous, and I fully support people who caution against that. In the study we're doing at the moment with advice services, for example, we found one client who'd been sent to the advice service from the government to get a government form because the government had put it all online and didn't have paper copies anymore. Now, that's obviously not okay. But we have to keep in mind that tech can be really helpful in a couple of ways. Firstly, it can scale up and reach a lot of people who have got the capability and access to use the tech. And also, it provides a really powerful tool for people who are helping the people who need the help. So legal tech can help the helpers. As I'm sure you'll have experienced, people will come to you for help, especially if you're a lawyer, but even if you're not, people who are less able will come and ask for assistance, elderly parents, things like that. So having legal tech available to the helpers is also a really powerful way of reaching more people. So those are my 4 myths that I wanted to dispel. But now to move on to 2 key messages I'd like you to take away when thinking about law and tech. Access to justice and tech more specifically. So the first one is the importance of collaboration, or if that can't be achieved, at least coordination. Legal tech and innovations in legal tech have a real risk of being lost in the wilderness. People develop amazing, innovative tools, but if there's nowhere to put them, then the end users can't find them, and that effort goes to waste. The other big problem with this is that once a tool has been launched, it needs continuous development, update, and iteration. One of the great strengths of the CRT that Richard just presented on and mentioned was that they continually iterate the design in response to user feedback. If that's not done, it will quickly fall out of date and not be useful to the user. So for legal tech to be really powerful, it needs to be linked in and closely related in this idea of linked to in-person advice and to the helpers and to the big websites where people visit. The conclusion that I've reached in research that I've conducted on how to go about scaling up legal tech to ensure access to justice, and it's a conclusion I noticed that the Hague Institute had also reached, is that what we really need is high-level leadership and collaboration and coordination to make sure that the legal tech reaches its promise of delivering access to justice. Now, that's very hard to achieve in practice because it requires governments, law societies, different organisations to come together, recognise there's a problem and put a plan in place. But the most successful examples internationally, that is what has happened. New Zealand's about to go down this path as well, so I can report back in a few years to see how we've gone. But I would emphasise to you as people in this field, where there are opportunities to advocate for collaboration and cooperation, that's what we should be doing. When people come to me saying, I've had this great idea for this great innovation, what should I do? My first question is always, who are you linked up with? Who have you talked to? Is this going to duplicate? How can it be linked into this network so that it's useful to the end user? The second key lesson is user engagement. Now, when we're trying to create legal tech to improve access to justice, we have to start with the people that we're trying to help. This has been a great strength of the CRT and one of its major reasons for its success. And legal design, the field that Margaret Hagan, who's speaking next, has pioneered, provides us with the tools for doing that, and she's going to speak to that. So let me just give you a couple of cautionary ideas about why this is so important, especially from a lawyering perspective. A lot of the people involved in trying to improve access to justice and legal tech are obviously lawyers because they can spot the problems. They're involved. But please remember as a lawyer that you have been taught to think like a lawyer. And that is not, as Elizabeth Mertz has pointed out, just a more refined way of thinking. It's actually a really specific, quite odd way of talking and thinking. And unfortunately, it means that we are not the best people to design things. I'll give you an example of the contrast in the way we talk. This might be a narrative of someone who is speaking about a justice incident someone's been backed into. They might start with a big statement like, people are so inconsiderate. And then they go on with lots of colourful language to talk about who was there and how they felt. A lawyer would take that and turn it into something like this. On or about the 25th of January, it's all about dates and places and times, and it's not a normal way of speaking. So when we are trying to help people with their dispute, we have to recognise that there's a really big difference in how we think and talk. So to give you the tools for how to engage in this way of thinking, I'm now going to hand over to Margaret Hagan, and thank you very much for your attention.
Thank you, Bridget. Let me multitask for just a second as I pull up my presentation. So my name is Margaret Hagan. I am the Executive Director of the Legal Design Lab at Stanford Law School here in California. And I wanted to just take a moment and recognize that Stanford sits on the land of the Ohlone tribe and to recognize their land and their history. So today I wanted to talk a little bit about the how of legal tech and access to justice. How do we do user engagement? How do we build really good tools that people will, in fact, actually use and that will be sustainable, much like the CRT? So my perspective generally at a university-based, law school-based lab is to focus on research and development around access to justice. What works? What can we be building, piloting, partnering around that will get to these justice impacts to increase legal capability? So that's the motivating factor for our innovation work at the law school. And I'll talk today about how we work and how other groups, sometimes it's called human-centered design, as applied in the legal field, legal design, or broadly in many government agencies and nonprofits, there's this growing field of civic design. So using design methods, which I will talk about in my first section, for legal problems, civic and government public interest problems. So I'll show you what that looks like in practice, as well as kind of what that structured process looks like. I'll show you some of the solutions, some of these kind of current and near future technology and also non-technology innovations for access to justice. And I'll close with a few mentions about forward directions, I think building off of Bridget's suggestions as well. So how do we actually do innovation? How do we come up with new technologies and improvements for access to justice? Like I mentioned, I'm the executive director of this law school innovation lab called the Legal Design Lab. We very purposefully focus on legal challenges like access to justice, but we employ methods from across campus, from across disciplines, often drawing on the design process and harnessing the power of technology. So when I say design process, here are some things of what I mean, at least in the abstract about that. Much like Bridget was saying, it means going to the community that you are trying to serve, that is dealing with the problem you are hoping to solve, and talking to them, hearing from them in their words, what their needs are, how they like to behave, how they use technology or don't. Also inviting them to be co-designers, to work alongside you as a professional, whether as a lawyer, a technologist, a policymaker, and work together to come up with feasible but also meaningful solutions. And having a commitment to experimenting, iterating, assuming that you're not going to come up with the perfect new technology right away. How do you have a commitment to getting feedback and then learning from that to make this thing you're building better? So those are some of the mindsets we have when we're talking about design. At the law school, we run design classes where we do this kind of work and we teach students and other professionals how to use design to actually tackle access to justice challenges. For example, this class back in 2017. So let me show you what that looks like in practice. Oftentimes, especially before COVID, but now starting again, it means going to where people are, where people with legal problems are grappling with them, trying to get services, or maybe even deciding whether to use the legal system at all. So for example, sitting in the waiting room outside of a traffic court in Oakland, California, and talking to people who are waiting for their court date or have just come out, kind of entry or exit interviews. Why are you here today? What would a good outcome look like? How did you end up here today? What kind of service could help you right now? Do you wish you had a lawyer? Do you feel confident on your own? Trying to understand litigants' perspectives and spot where there might be opportunities for new technology or other interventions to help them. Also interviewing advocates, people who have seen many, many different clients and users, situations, and who know the policies and structures around the system to say, what is their agenda? What are the needs and opportunities they see that they would direct us to focus our work on? Coming together and in this design process, after talking to many, many people, looking at data sets, watching proceedings, looking into what works and what doesn't, mapping it out and trying to make sense. Where is there an opportunity that we could use technology or another kind of new pilot to actually make a difference? Drawing out exactly how a person goes through a court process. Again, kind of doing this kind of mapping work to spot the opportunities, to spot the spaces where an intervention could be meaningful. The same thing with the legal process, mapping it out, not from a policymaker's perspective, but more from a litigant or a user's perspective. How does a person actually go through a legal process step by step? How do they interact with the rules and the laws and the services? And where are there the big breakdowns where they get lost, confused, frustrated, have to spend a lot of money? Use that again to decide where to focus, where could we be improving the system? And then we start to go from understanding and identifying opportunities to actually doing creative work, brainstorming ideas, taking a look at Boston Housing Court and saying, what if we could put a big subway map on this big, beautiful wall? What if we could lay out step by step what an eviction process looks like? So all these people in the waiting room could know what to expect or what the judge is going to ask them and how to be prepared. We come up with tons of ideas and we use these design methods, these creativity methods to try to brainstorm lots and lots of feasible and kind of wild out there ideas about how to solve a given problem that we've identified. And then gradually go from this huge wall of ideas down to a handful that are worthy of actually prototyping. And so when I say prototyping, that doesn't mean a full pilot that is well funded. It's more a first attempt, pretty scrappy with little money put behind it, but something that we can invite litigants or service providers in and test with them. So taking this kind of scrappy startup approach. So like, for example, in this picture, we've made a sample poster of how to navigate traffic court. And we've recruited 20 people from the region who have had traffic ticket problems. We invite them into the lab. We pay them $40 for their half hour of time. And we ask them, What do you like and what do you not like about what we've put in front of you? Would you look at this poster? Can you understand it? What would you change about it? Trying to see if it's good or bad, if we should scrap it or edit it to make it better. Have them rank different ideas against each other so we can start to see which model seems to be the most engaging, the most useful for people. And especially with new technology products, whether it's a text message hotline, a new app, a new website, inviting sample users in, compensating them for their time, and asking them basically to tear our app or our thing apart. Where is it confusing? Where is it buggy? Where does it have the wrong tone? You tell us all the problems. So before we release it to the public, we know that we have a strong or the strongest possible offering. Then after we go through this prototype and testing stage, then we think about a formal pilot where we're advertising a new product or a service. We are trying to get as many users as possible. We're still gathering feedback, sometimes through a randomized control trial to really see if we are making the impact we hope. Sometimes when that's not possible, through a more just kind of observational trial to see if people are using it and if they are able to take the next step or get to a better outcome. But that's when it's kind of more live. If a pilot is successful during that first month or 3 months, then thinking about scaling, trying in our United States context, at least where we have many different labs of democracy across the many states and counties, trying to say, hey, we found something that worked in this local county. For example, this eviction summons that we worked on in Cincinnati, in Hamilton County, Ohio. We got one court to really make a visual transformation of how they notify people that they're facing eviction. We piloted it, we did all of the testing, we launched it, it was successful. Now, how do we get as many other jurisdictions to borrow it wholesale or to use its principles to transform their own work? So let me show you some of the examples that have come out of our innovation lab at the law school and some other innovation labs. We go from visual designs to new tech to also kind of systemic changes as well. So let me show you some visual designs. I've already hinted at some of them. Redesigning court documents, just using basic visual design principles about white space, hierarchy, clear messaging to make these pieces of paper much less intimidating and more useful to people. Laying out clear step-by-steps of how to actually navigate a legal process. So whether that's on paper or on an app or on social media, dividing up complicated legal system guidance into clear visual narratives that take a person through the steps, almost like reading a cartoon of how you can navigate a process. Same thing for debt collection, another visual guide. This one's for eviction. You can see the pattern, dividing up the process into clear step-by-steps with pictures. Tech tools, let me show you some examples. One are websites or native apps that, again, lead a person through a process. Let's say filing for a restraining order, step by step, and having all of the resources, referrals to help agencies, and forms and kind of court links all in one guide, but dividing it up in a staged step by step. Text message. Here in the US, this is much more popular these days than websites, to have people go through intake, to sign up for services, to give feedback, all through text messages. Also to make national websites, like Bridget was saying, having big platforms where the most common kinds of FAQs, step-by-steps, and tools can all be at a relatively discoverable site that Google will rank relatively high so people can find this key reliable information. And then there's this near future of data and AI in access to justice. So we can use data sets from legal aid groups, clinics, and courts to start to see if there's seasonal patterns of when certain legal needs seem to be more common than others, like education-related problems spiking at the beginning of our school year here in the States in the August to September range. Can we then have more pro bono clinics or other services available during that seasonal peak? Also using AI to possibly spot in a person's paragraph when they're typing in their problem while applying for legal aid, or typing up their problem when they're asking people on Reddit for help. Having an AI tool that can read that text and try to identify what legal issue is there. Our Stanford lab has been working with the Suffolk Lit Lab at Suffolk Law School in Boston to build these kinds of AI tools. And we have them living on, for example, Reddit Legal Advice, a subreddit where people share their legal stories. And we are spotting people's eviction problems and referring them to reliable legal aid websites to follow up with more information. And then, as future sessions of this conference will be pointing towards, there's lots of policy and reform things to be thinking about. I won't go into depth, but definitely thinking about new regulatory models and regulatory sandboxes, and how we can use collaborative multi-stakeholder design processes to get lots of voices in that design of new regulation. Same thing with reworking virtual courts. And I'll just say on the scale factor, like Bridget was alluding to, we've been trying very hard in our lab, not just to work with one-off pilots in one-off jurisdictions, but trying to set national or maybe even international agendas of what promising practices there are for new tech and services, and trying to lead peer cohorts or other networks to spread those best practices as far as possible. So I'll sign off right now just with a few thoughts about where the future is going for this line of work. One is more global exchanges so that we are not doing the siloed work as much. And as Bridget was saying, that we are building off of each other's work in a more collaborative way. Having more metrics around what's actually improving access to justice and what's improving people's legal capability, those shared metrics would go a long way in helping us evaluate what works and what doesn't. And also involving more types of professionals. I think in the past 15 years, we've had lots of early adopters, self-identified, innovative lawyers and judges who can't wait to do work on pilots. But I'm very interested in not just those most innovative and early adopter folks, but trying to get more folks in the profession to be open to new pilots and innovation work. So I'll say thank you, and I'm looking forward to the Q&A session now.
Thank you, everyone, and bravo for keeping relatively to time. That's always a challenge, and we appreciate it very much in the interests of equity and making sure we get to as many questions as possible. And I have to say, I've got a million questions, but I better seed the ones that have been put by our audience first. And amongst them are some really interesting ones, mainly for you, Richard, I think, because people are so interested in how the CRT works. But from that, I think will flow some really interesting prompts for Margaret and Bridget. So can I just ask you all at this point to jump in if you hear a thread of something you'd like to make a comment on or that resonates with your own work, then please feel free to come in and don't wait for me to prompt you. So the first question that came up, Richard, which was around the challenges, I suppose, of engaging with the CRT, and one I'm sure that you've dealt with many times, which is around what about the digital divide for people who are, older and not familiar with the technology for an online system like the CRT, or have an access issue in terms of disability, or are in regional and remote areas where online engagement is more difficult. Are you working on ways to respond to those diversities in your community?
Certainly at the CRT, we have strategies for dealing with the digital divide, although I'll just step back and say prior to starting, and this was a survey done in 2014, so now 8 years ago, to address part of those concerns raised by the community when they were thinking about doing online justice, and there was a lot of resistance to it at the time. And so we went out and did this survey and found that well over 80% of the respondents to that survey have used technology to conduct some sort of business on a weekly basis, at least, whether it be banking or buying something online. And that has only increased since then. And this is going to vary from jurisdiction to jurisdiction. But the other advantage we have here in Canada and BC is there has been determined effort by both our levels of government to increase access to high-speed internet throughout our province and across the country. So there are most of the rural areas, most of our First Nations who will have or do have access to high-speed internet, although the definition of high speed will of course change over time, but generally our services don't require a huge amount of bandwidth. But the other thing, the key thing that we did is recognizing that there are people that are going to have a higher level or less confidence in dealing with us online, is we have multiple ways of accessing the tribunal. So although most of our services are provided online, we will accept things in a paper form, or they can fill out a PDF form and take that down to, there's various government offices around the province that we have arrangements with, and they can file it there and pay there as well if they don't like online payment. So we have primarily recognized it through allowing those different areas or different ways of accessing our services. And that includes the entire process, not just application.
Right, okay. So keeping the options open in terms of...
Yeah, although I should add that it's probably at this point, I would say less than 0.5% are doing that.
Yeah. Bridget, do you know anything about, I mean, the reality of the digital divide? Because I think it's one of those issues that comes up over and over again as being, you know, a significant challenge in the proliferation of online responses. But I wonder how real it is.
Well, I think it's pretty real. There's debate about it and what you mean by it. So, you know, there's the simple connectivity of having an internet connection, but then there's having a device which is good enough to conduct that kind of business. And then there's the work that a lot of your colleagues at Victoria Law Foundation have worked on with legal capability and being able to actually engage with that. So there's quite a few layers to it. So I'm very reluctant to dismiss it as something that's small, because I think it is really important. But we also have to put it in perspective, and you know, this idea about other people helping as well can be really important as a way of thinking about who's accessing the service. It might be via another person too.
Just thinking about capability, which raises another question that came in from one of our audience today, Richard, around the level playing field or not in terms of facility with language, with these sorts of disputes, and whether or not there's effort to try and level things up between, for example, a tenant who's taking issue with a landlord, and a landlord who may have been through this process many times before and is pretty au fait with the way things get done. Is there a way to support the less experienced participant?
We do that. Of course, there's legal limitations on how far we can go with that, but certainly through our intake process or response process, we don't provide necessarily call center support, but there is access to information either through email or they can call in and get assistance with specific forms and so forth. So those, I think, it's building a level of comfort with people who might feel intimidated by the process, more so than being intimidated by the party on the other side. There's just nothing we can do to eliminate that level of experience, because we have parties who, we refer to them as our frequent filers, for example, who for business reasons appear before us fairly regularly. When it gets into the facilitation or mediation type stage, then we have case managers who, again, being cautious not to cross the line into advocating for the other party, but making sure they have a level of comfort with what do I do next and what is the process, and not feeling that the other party, because they have been there before, will be able to pull some kind of trick or something like that because they are more familiar with the process. The other thing we do is we discourage actively or deter unnecessary preliminary procedures. So the focus is on a fairly linear process, very few interlocutory type applications in advance of the full decision. So we won't allow parties to be sort of bamboozled by various motions and requests for CRT preliminary decisions.
So just to I think, give that a little more depth, how many of your negotiations, and I think I remember you gave a pretty low stat on this, resolve at the negotiation stage?
admit we don't have exact numbers on that because of the way our statistics are working, but it is anecdotally less than 1% of our disputes that, now we lose a lot of disputes at intake because either we determine we don't have jurisdiction, which is probably about 3% of them, and then others, the applicant will withdraw because the other party responds and pays, that sort of thing. So we're probably losing 10 to 12% before it even gets to that negotiation stage, and then another 25 to 30 where the respondent never responds at all. So they go off to a default process. But for the rest of them, of those, slightly less than 1%, as I say anecdotally, come to some sort of conclusion through that negotiation portal. At that point, they will notify us and it gets raised to one of our case managers who assist them in finalizing that. So there sometimes is a little more work to be done to actually make it a true settlement, but that's, as I say, anecdotally. Overall, only about 20 to 24% of our disputes go all the way to an adjudication stage. So they're either resolved through default or through that facilitation and negotiation process.
Very interesting. Margaret, you mentioned a couple of times the efforts to, I suppose, spread the love in terms of the beautiful documentation that some pilots have generated around pretty standard but still painful legal problems that people have. You didn't tell us how successful that is in making other counties and other states pick those ideas up. What is the proliferation like?
I think right now it's quite happenstance. So we've had luck by posting on listservs. In the US context, we have a few wonderful list hosts like SRLN for Self-Represented Litigation Network or LSNTAP and kind of legal aid technologists. We can post, look what we've done here. We've had promising results. And then we'll get a few judges here, a few judges there. If we're lucky, we'll get a whole state. But that's definitely one of the problems we grapple with. That could be the structure of the United States and that there isn't a federal agency devoted to funding and incentivizing and pressuring the adoption of best practices. But I think with COVID, we have seen with especially the eviction and unemployment crises that hit, a lot more interest in people from around the country getting on phone calls, hearing best practices report what's happening in Louisville, what's happening in Philadelphia, what's happening in Austin, and at least taking notes to say, here is a model we could implement. Of course, then there's always local politics, leadership, and will. So it still is quite happenstance. And that's one of the kind of themes of upcoming work is how to get data standards projects that can put people on the same standard so it's easier to replicate pilots, and how there might be other federal or national institutions to reward and incentivize the spreading of promising pilots.
I'm really interested in the resistance because I think, and as you mentioned, Bridget, leadership is a key dimension in this. You really do need, somebody in a position of significant influence to really drive this kind of change. And forgive me if this is problematic for some of the lawyers in our audience, but you feel this level of resistance in a fundamentally traditional, fairly conservative, hierarchical profession against cartoons or photograph processes for offering people support and advice. Bridget, have you stumbled across resistance and, more importantly, I suppose, an articulation of that and why there is that stuff that needs to be overcome and how we can overcome it? There's a triple banger for you.
Yes, I think there is resistance to a certain extent, although there are a lot of younger practitioners and even older practitioners who are fed up with the situation. So I actually have a fairly optimistic view of the profession to get in behind it if there's enough leadership. I think some of the resistance comes from this really core tension in our courts about the fact that we are obliged constitutionally to welcome in self-represented litigants, but there's also very much a keenness to keep them at bay because of all of the complications that brings. And I think some of the resistance could be traced back to that core tension, which we're really yet to wrestle with. But I do think with leadership, well, I'm hoping it's going to work in New Zealand. We're a small unitary jurisdiction, and our Chief Justice and our ministry are behind the work. So if we can't do it, then I'm going to have a gloomier view, but hopefully I can report back with a success story, somewhat modelled off what Canada did, and the great success that Canada are having. So yeah, I prefer to stay on the optimistic side.
Well, that's terrific to hear. But what's your time frame, Bridget? When can we have you back on the post-mortem?
Do some lawyerly fudging about now. Yes.
Fair enough. Richard, I mean, the CRT has been in operation for some time. Your jurisdiction has expanded twice, as far as I'm aware, into new spheres. Is it now entirely embraced and accepted as a part of the legal environment here to stay in British Columbia, a model for not only Canada, but for the rest of the world? Do you think it's now well established and locked in?
I believe so. It's certainly reflected in the fact that government, when they had a major policy issue with basically automobile insurance, and as part of that solution, they looked to the CRT to provide the dispute resolution body. I think that reflected that government has certainly accepted the CRT as being, as I say, part of the justice system in my presentation. I am sure you could ask members of primarily the legal community here in BC, and they may disagree with that. There's certainly still some resistance to the CRT in light of the fact that we have a statutory provision essentially that restricts legal or lawyer participation in some of our dispute areas. And then the other thing to note is just that we're still, of all the various disputes, whether it be court or other tribunals, still just a very small portion of that, that's 7,000 disputes per year. So we are not commonplace, let's put it that way. Although, quite frankly, we do get a fair bit of play in the local news media about some of our decisions that are sort of novel.
I bet, and given that they're all online and searchable,
exactly.
I think, it would be.
They subscribe to the decision, so they see them as soon as they come out. So,
of course they do. Any sensible journo would be on that on a very regular basis.
Sometimes an easy story.
Yes, exactly. Margaret, I'm going to wrap with you because I think there are so many threads in your work in terms of the various dimensions of tech that you've worked with, together with the old school basic of actually talking to people and finding out how they experience this system. How is all of that coming together, or what do you see as the next sort of phase of civic design, which is a phrase I've learned from you today and I'm very grateful for?
Yes, well, I think there's going to be an expansion of how we get more people's voices in the process. So like I was saying, before COVID, our main strategy was to plant ourselves in places with high traffic, with places we could recruit people in person. But with COVID, we were forced to be a little bit more scrappy to get to talk to people. So finding people online, recruiting large amounts of people for whether it's 30-minute conversations, quick testing of a website or an app, or like large scale surveys like Victoria Law Foundation does. I think there's just such a wealth of innovative tech and in-person research methods to get user voice in at the beginning, to scope where should we think about setting a tech agenda around, as well as in user testing and constant feedback. So hopefully we will see kind of an explosion of how to make that operational and less aspirational, so that there are just regular amounts of potential users and actual users of the courts telling us where we should be setting our agenda and how things are working. And then, like has been mentioned several times, that great ideas that are popping up around the globe are really then inspiring replication around the world, and that we are all talking to each other to see what really works on the ground.
Well, we are completely delighted to be the vehicle for keeping that conversation going, and hopefully the coalescence of so many different ideas and experiences. So I think we are eternally grateful for your time and expertise. Thank you so much for kicking off the conference. It's been terrific to have you joining us today. Of course, Richard Rogers from the Civil Resolution Tribunal in British Columbia, Bridget Toy Cronin from the University of Otago and Aotearoa, New Zealand, and Margaret Hagan from the Legal Design Lab at Stanford. It's been a joy. Have a wonderful day. Kick off the conference and lead on to the next one if you'd like to join that session on deregulating the profession. And if not, then we'll see you later in the conference. Cheers. Have a good day.